Hi friends and professional colleagues. I am Rajender Goswami, Assistant Company Secretary at APAC Associates LLP. This is the 20th video of APAC's web series that is One Concept, One Slide, initiated by APAC Associates LLP. This presentation is about the concept of voluntary liquidation of a company or LLP under Insolvency and Bankruptcy Code 2016. It occurs when the members of the company or LLP formally resolve to voluntarily wind up the affairs of the company or LLP and dissolve it. We look forward to receiving your queries, comments, and feedback by any means given on the slide. The objective of voluntary liquidation of a company or LLP is to enable the members and the creditors to settle their affairs among themselves. Voluntary liquidation is an option available only to solvent persons. The purpose of voluntary liquidation is to terminate a company or LLP's operation, wrap up its financial affairs, and dismantle its corporate structure in an orderly fashion while paying back the creditors according to their assigned priorities. The process begins with the finalization of a statement of assets and liabilities of the company or LLP or as on the latest possible practical date, which will represent the position of its assets and liabilities on that particular date. That is to say that the total assets of the company or LLP available for disposing of and the total amount of liabilities that needs to be paid to the creditor known on that date. Next is the preparation and signing of declaration of solvency by the majority of the designated partner in case of a limited liability partnership and majority of the directors by holding a board meeting in case of a company, verified by a affidavit stating that it has no debts or that it will be able to pay its debt in full from the proceeds of the assets to be sold in the liquidation and it is not being liquidated to defraud any person. The declaration shall be accompanied by first the audited financial statement and record of business operations of the company or LLP for the previous 2 years or since its incorporation, whichever is later. Second, a valuation report of the assets of the company or LLP by a registered valuer. Simultaneously, the proposed liquidator of the company is required to submit his online consent to act as a liquidator to the Insolvency and Bankruptcy Code Bankruptcy Board of India, that is IBBI, on their portal and a written consent to the company or LLP. Further, within 4 weeks of this declaration of solvency, a resolution shall be passed by the majority of the partners or contributories, as the case may be, of the company or LLP, requiring the company or LLP to be liquidated voluntarily and appointing an insolvency professional to act as the liquidator, and such resolution shall contain terms and conditions of the appointment of insolvency professional, including the remuneration due to him. The date of passing this resolution is deemed to be the date of commencement of the voluntary liquidation. The company or LLP shall, from the voluntary liquidation commencement date, cease to carry on its business except as far as required for the beneficial winding up of its business. Further, in addition to this, where the company or LLP owes any debt to any person, creditor representing 2/3 in the value of the debt of the company or LLP shall approve the resolution passed by the majority of the partners or contributories, as the case may be, within 7 days of such resolution, and no deed of this resolution if there are no creditors. The board of directors or the designated partners shall cause the necessary documents like declaration of solvency to be presented to a creditor before his approval is obtained. The liquidator shall intimate the ROC within 7 days of approval of liquidation of the company by the partners or the shareholders, or after subsequent approval by the creditors owing 2/3 of the value of the debt of the company. This special resolution is to be filed in the form MGT 14 and the declaration of all insolvency and appointment of liquidator in form GNL 2 to the registrar of the companies. Intimation shall also be sent to IBBI within 7 days of the approval of liquidation of the company or subsequent approval by the creditor through email. Afterwards, within 5 days of the commencement of voluntary liquidation and liquidation process and liquidator's appointment, a public announcement is required to be published in one English newspaper and one regional language newspaper having wide circulation where the registered of the office of the company or LLP is situated. Also, the liquidator shall intimate IBBI through email regarding this public announcement and also update the same on the website of the company or LLP if any. The public announcement shall first call upon the stakeholders to submit their claims as on the date of commencement and provide the last date for the submission of claims, which shall be 30 days from the date of commencement. Also, the liquidator is required to intimate the income tax authority and the bank where the bank account of the company is opened regarding the commencement of voluntary liquidation. On intimation, the bank would close the existing bank account and open a separate bank account of the company or LLP, followed by the words in voluntary liquidation, or simply change the nomenclature of the existing bank account. Further, a person who claims to be a stakeholder shall submit his claim for debt or dues to him as on the liquidation commencement date, including the interest within 30 days from the liquidation commencement date. There are different ways specified in the regulations to submit this proof of claims by the creditor depending upon their class, wise by post or by electronic means or etc. The liquidator shall prepare and submit a preliminary report within 45 days from the date of liquidation commencement to the ROC in Form GNL2 and to IBBI through email containing the following. First, capital structure of the company or LLP, estimates of assets and liabilities as on liquidation commencement date based on the books of the company or LLP. It shall also contain whether the liquidator intends to make any further inquiry relating to the promotion, conduct, formation of the business, and proposed plan of action by liquidator, including the timelines within which he proposed to carry it out and the estimated liquidation costs. In the next step, the liquidator shall verify the claims submitted and may either admit or reject the claims in whole or part as the case may be. Based upon the verification of claims, the liquidator shall prepare a list of stakeholders within 45 days from the last date for the receipt of the claims on the basis of the proofs of the claims submitted by them and accepted by the liquidator. And the list shall contain the following. First, the amount of claim admitted if applicable. Second, the extent to which the debts or dues are secured or unsecured if applicable. Third, the details of the stakeholder. And the last, the proof admitted or rejected in part and the proof wholly rejected. Next step is the realization of the asset by the liquidator. The liquidator may value and sell the property of the company or LLP in any manner and through any mode that is approved by the company or LLP. The liquidator shall credit to the bank account all monies opened for the liquidation process, including checks and demand drafts received by him as the liquidator, and the realization of each day shall be deposited in the bank account without any deduction not later than the next working day. Post realization of the assets, the liquidator shall begin with the distribution process and the proceeds from realization shall be distributed to the stakeholder in the order of priority as provided under section 53 of the Insolvency and Bankruptcy Code 2016, that is as per the priority waterfall chart. Post completion of the entire liquidation process, the liquidator shall prepare a final report consisting the following. First, an audited account of the voluntary liquidation showing the receipts and payments pertaining to the liquidation since the liquidation commencement date. Second, a statement demonstrating that first, the state of the company or LLP has been disposed of. Second, the debt of the company or LLP has been discharged to the satisfaction of the creditor. And the third, no litigation is pending against the company or LLP. The last one in the final report is a sale statement in respect of all state. Now the liquidator shall send a final report to the registrar in Form GNL2 and the IBBI through email. When the affairs of the company or LLP has been completely wound up and its assets completely liquidated, the liquidator shall make an application to the adjudicating authority, that is NCLT, for dissolution of such company or LLP. And that application shall consist the following: synopsis of petition, list of events, notice of admission in form, an affidavit verifying the application, memorandum and article of association and extract of master data, declaration of solvency along with its annexure, Form GNN2 with paid challan filed for declaration of solvency, members resolution and notice of AGM, copy of consent of creditors, public announcement in newspaper, copy of Form MJT 14 and GNL2 along with the paid challan filed for the appointment of liquidator, claims for liquidator, primary report, no objection certificate from income tax authority, certificate on the liquidation showing receipts and payments pertaining to the liquidation, final report, and GNL2 for submission of final report with ROC along with the payment receipt and proof of dispatch to IBBI, certificate from blank closure of the account, demand draft, memorandum of appearance along with resolution. NCLT shall, on the application filed by the liquidator, pass an order that the corporate debtor shall be dissolved from the date of that order, and corporate debtor shall be resolved accordingly. Also, a copy of this order be forwarded to the ROC in the Form INC 28 in case of a company and LLP within 14 days from the date of such order. Now some other points that shall be kept in mind related to the process, which are the following. First, the liquidator shall preserve a physical or an electronic copy of the reports, registers, books of account for at least 8 years after the dissolution of the company or LLP, including the proofs of payment and receipts made during the liquidation process. Second, professionals after the liquidation commencement date shall appointed by the liquidator through an engagement letter, and their fees shall form the part of the liquidation cost. Third, the liquidator shall endeavor to wind up the affairs of the company or LLP within 1 year from the voluntary liquidation commencement date. Otherwise, the liquidator shall do the following. First, call a meeting of the contributories of the company or LLP within 15 days from the end of each year in which he is appointed, and at the end of each succeeding year thereafter, and shall present a status report indicating progress in the liquidation, showing the receipts and payments pertaining to the liquidation. Fourth point, all the documents signed by the foreign director and designated partners, such as affidavit verifying the declaration of solvency, shall be apostille and consolidated as the case may be. In this case, post-remittance, the liquidator is required to file FCTRS with the Reserve Bank of India for cancellation of the shares of the company and capital contribution of LLP as the case may be. Further, in absence of any of form for LLP, it is suggested to submit the required document with ROC both physically and through email, and all the payment of the government dues and NOC from the income tax department is to be availed before the application to the NCLT for dissolution. You can refer our other videos already published on your YouTube channel. You may subscribe for our weekly lights and monthly light newsletters for all latest updates in the areas such as SEBI, FEMA, Companies Act, etc. Please follow us on Facebook and LinkedIn page for daily updates by referring the details given on the slide and in the description box below. We have tried to cover all about voluntary liquidation of a company or LLP, the step-by-step procedures involved therein, and the documents involved at each steps along with their timelines. We request you to share your views and advice on this web series, including the topic that you want us to cover in the coming videos. Thank you.